Thank you. Minister Lametti. I'm troubled by the Trudeau government's paltry record of transparency about legislative consultation. Senator Carignan had to ask you twice for a list of stakeholders on our Bill C-28 study, and you still wouldn't reveal what advice those particular stakeholders had given you about direction for that bill. Now, for this bill, the government conducted legislative consultations in 2017, but Bill S-11 wasn't introduced to Parliament until 5.5 years later. You still haven't told us which stakeholders were included in those consultations, nor what their advice was. Have the concerns that were raised by stakeholders during those initial consultations been addressed in your legislation?
The substantive answer is yes, those concerns were addressed. There's been extensive consultation in every single phase. This is the fourth phase of harmonization, a process that began in the late 90s. Under different governments. The last harmonization bill was brought forward by Rob Nicholson, and as I mentioned before, it received unanimous consent. All of the bills received unanimous consent, and I hope this one will too. There have been extensive consultations with provinces as well as stakeholders, all the bar associations of each province, and the suggestions made were taken seriously. Many of them were incorporated. The ones that weren't incorporated, in principle, I'm roughly translating what Maître Allard said a moment ago, but the ones that weren't incorporated were either out of the scope of the bill. These harmonization bills are meant to not change the substantive law. They're meant only to harmonize. And so a number of the changes that were made, including a number of the changes proposed by the Chamber of Notaries in Quebec, would have actually expanded the scope of the bill or changed the scope of the bill. And so those kinds of suggestions were not retained. The other kinds of suggestions as a category that weren't retained were those that didn't necessarily fall within the drafting practices of the government. So there is to cite an example, the principle of brevity, I suppose. State the provision in the shortest way possible. Some of the suggestions that were made would have expanded or unduly complicated a definition. So all of those were taken into account, and we have, and the same process was effectively used for every single consultation for the 4 stages, and it's with improvements made along the way. And we're happy to provide a list of stakeholders.
That would be much appreciated, so that we can have an idea whether the stakeholders' concerns were addressed or not. But Minister, the Trudeau government's insistence then on forcing this huge bill through, I mean, look at the size of it, through the Senate just before Christmas break is indicative of their lack of respect for the work of Parliament. We have extremely tight time frames for turning this bill around, yet we haven't been able to secure witnesses for these hearings because of that, other than officials from your office and department. So it's difficult for us to provide sober first thought, because you initiated this bill through the Senate. When we don't have the time or required information, we need to hear from a balance of witnesses. And also, we're expected to vote on this bill clause by clause this afternoon. So I have great concern with us being asked to pass something in such a rush fashion when we know there are concerns out there from key stakeholders that our committee won't have time to hear from or consider. And so I'm aware of the Chambre des Notaires du Québec submitted an application to appear before our committee, but we haven't had time to receive a translated copy of their letter yet. They have concerns that some federal laws would not be amended by S-11, and this group was part of the original 2017 stakeholder consultations, and their letter provides a number of recommendations with technical amendments. Have all of those recommendations been incorporated into the bill, other than ones you've already spoken about, and if not, why not?
I've already given the answer. So the amendments proposed by the Chamber of Notaries in Quebec were all considered, were all duly considered. A number of them were incorporated. The ones that weren't not incorporated either expanded the scope, the conceptual or substantive scope of the laws in question, or they would have a similar impact, but the drafting rules of thumb, if you were, as it were, meant that they they would have rendered the structure of the translations heavier or more complicated or otherwise inconsistent with other drafting practices. I have seen the text of a response to those concerns, and I know that text has been forwarded. I don't know that you all have had access to it yet, but you will get access to that in very short order.
Hopefully before clause by clause. Minister, I see at several places in this bill the title for Her Majesty has been changed to His Majesty, obviously to reflect a change in the monarchy with the recent death of Queen Elizabeth II and the ascension of King Charles III. For example, clauses 528 through 530 reflect such changes to the Cultural Property Export and Import Act at page 180 of the bill. So I'm assuming that Bill S11 does not contain every such instance in Canadian law where Her Majesty must change to His Majesty or the word Queen must change to King, given that such words are considered interchangeable under the Interpretation Act. So why then did you choose to include some of those terms in this bill and not other ones?
I will turn to my colleagues for that.
So you're correct that the Interpretation Act means that references to Her Majesty are now considered to be His Majesty, but as a matter of legislative drafting practice for any new legislative texts that have been introduced since the demise of the Crown, it has been our practice to refer to His Majesty.
So why then was this bill including some changes to His Majesty but not all of the changes?
Because we were only addressing those references that specifically included Her Majesty. Those specific references would have been changed, but as you know, throughout the legislative corpus, there are many references to His Majesty. So as a matter of legislative practice, we only made those changes to texts that were being amended, to the specific provisions that made the reference to Her Majesty. Those references would have been changed to His Majesty. But if, for example, one of the bills that was being addressed did not, the harmonization amendments did not include references to a previous text that read Her Majesty, that would not be addressed by way of an amendment to the legislative text before us.
So you're only dealing with those 51 bills, is that why?
No,
51 that are
it's
included?
because of the texts that are included, that are being harmonized in the 51 bills, any references to Her Majesty would have been changed to His Majesty. But if a bill is being amended, even if the underlying bill includes references to Her Majesty, because they were not being modified by this bill, we would not make the change to Her Majesty because, as you know, the Interpretation Act addresses that.